go from there. So that's fine. So welcome to this succession asset protection and estate planning workshop. So I've got obviously myself, Tony, which you've just had a chat to. So hi, Tony, how are you?
Good. How's yourself?
Yeah, good, thank you. And I've got Tim Munro and Michael Jeffries. I'm not sure if they're there, Tim, that they haven't come
Hey, Grant,
on.
how you doing?
Oh, well done. Thank you very much for that, Tim. Sorry about all the stuff up, but unfortunately, Hey Summit and I don't know what's going on with Zoom, but we're having a bit of problems in the last few weeks. But obviously, they're just getting overloaded with stuff. But how are things in your neck of the woods, Tim?
Yeah, Grant, things are good. Yeah, it's just a busy time as usual. I think everyone's just getting through JobKeeper 2 applications, finishing JobKeeper 1, getting into the tax side of things. And I tell you, what you're talking about today is pretty massive because
Well, I think it's
I'm inundated with this work right now, absolutely inundated.
I know. So, I mean, that's the hard thing is, although our systems are really quick and you'll see, and I'll explain it, but it is, we're just getting so many, we're getting so many people coming along. And particularly even in the planning space that see this as a great opportunity. And obviously, Tony and I will talk about the legal side of things a little bit later on, but it's certainly tip of the mind for virtually everyone. And I know you've got a brilliant package there. Are we going to see a bit of change GPS magic a little bit later on, Tim?
Yeah, we will. I think the key thing is I'll show and take everyone through the what we call the client education or offer document, which will go through everything to get the prices and to convey the value to the client.
Fantastic.
Now, we've started the process of putting that into an app. It won't be ready till next year. We've had to do a few other things first.
We all know what apps are like.
But Change GPS members, if they contact me today after this event, for those that are on this, I'll send them this document and they can start to use it.
Fantastic. And look, for the non-change GPS members, I'm going to take you through some data captures, email done for you, etc. So there's a lot of stuff that's going to go through. So we want to take you through the whole process. But look, just to give idea, Tim, because you've been in the trenches there for a while, just to give people a bit of a base, having a look at the Protector, this estate planning, successor directors, EPOAs, all of that sort of stuff that we're looking at doing, leading member trusts. Obviously, you've done your sort of budgets. What do you expect would be a reasonable midpoint for extra revenue coming in for the year, just in your own business?
Oh, goodness. Well, to give an example, like I've just finished about 11 Protectors just over the last 2 months. We charged $5,000 for each of those. I've got another 4 coming up just to do over the next, probably about another 7 coming up over the next month. On top of that, wills, EPOAs, advanced health directives for a couple, we'd start at $2,500 plus GST and work up from there. And that would include having, you, Tony, on for an hour and paying you the $450, whatever that is, to have the proper legal chat with the clients and that sort of thing. But it's a very quick process, and I like the fact that you've added a lot of stuff. For example, the wills, you've added things like digital assets. And
first in Australia to do that.
It's brilliant. And I'm actually going to be upgrading my wills on the weekend. Lyndall's and myself, we're just going to go through and use the whole process and upgrade the whole lot. So I just, look, everyone will see these things today. I'll just be saying, do it for you. Everyone online, do it for you and your family over the weekend. Get a feel for it. Then offer it to your team. Do it for free for your team so they understand the process, and then roll it out to your clients.
That's perfect. Well, I'll jump into, thanks for that erudite conversation there, Tim, as to be expected. But look, there's so much opportunity here, and I think it's the main thing. It's a $3.5 trillion market. There's going to be a switch of wealth over the next 15 years. So, given the fact of where we are in that cycle, particularly once JobKeeper and all that runs out, you're going to see that it's like we've had a tsunami. Now the water is going to start to recede. And obviously there's a huge amount of issues, particularly down Victoria, which is having a huge dragging effect on the Australian economy. But let's go on. I think the main thing is today is with Lightyear Docs, Abbott Morley, and certainly Change GPS, etc. and we're going to have Michael Jeffries a little bit later on from Optimum. You know, we're there to basically be your strategy engine. Technology these days allows you to punch so far above your weight. And you can see our little Buzz Lightyear, which is where we essentially got our name from. So, and that was to now infinity and beyond, which I thought was quite funny. Some rules for today. We are doing a recording. So what I will do is when I find it right, I'll actually do a break in between sections so we can actually have sections, and hopefully they'll be up later on today, definitely by Thursday. So you're going to get all the recording. So you have to drop in and out. You've got a lot of client matter for those people who have had a few issues. Then effectively what we'll do from there is the recording will be up and available. And of course, you can always ask a question on the support side at Lightyear Docs or to Tony. So Tanamoulis, TANAMOURLIS at abbottmorley.com.au if you'd like to book in a session. And we'll talk about that a little bit later on. Now, there's a lot of content and ideas, but what I have done is I've pulled back quite a bit, mainly is, you know, I know my system really well, and I have to give you a lead in. So some of the key documents we're going to be looking at today are obviously the duals, so the spousal or husband and wife wills and EPOA, just the basic ones. Then we're going to go into probably doing a little bit of SMSF work. You'll find for me, the big switcheroo came for me in fact, I just had a look at my in fact, it was our March 2020 conference and had a look at our 2-day conference. And really, in those days, I was pretty heavily SMSF. And now I probably spend about maybe 5% of my time in SMSF. I love the stuff, but it's just not where the business is or where the money is. You know, Tim's is an epitome of success when you have a look. He's charging $4,000 to $5,000 for a protector. He's done 20 of them over the last 4 or 5 months, and you guys should. And we're going to be I'll show you that a little bit later on. But essentially, from that perspective, there's no way in the world you'd be able to get that amount of new clients on the new advice. Certainly at Abbott Morley, we're getting requests for a lot of advice and fixing stuff up. But again, this succession asset protection estate planning is the real key for us. So as you go along, just sort of sit back and probably I definitely follow Tim's advice. And I know Travis from our crew is also the same as do the wills and EPOAs for yourself. In fact, I've just done my lot. Yeah, I had my discretionary trust, which I upgraded to a leading member discretionary trust. Same with my SMSF. So use these tools for yourself, understand why you're doing it, and we'll go through that today. Do it on your staff as well, practice, and then start rolling it out to the clients. Ask questions along the way. You'll see there's the Q&A button. So the good thing about the Q&A rather than chat is if you ask questions, Tim or Tony or Michael or myself will be able to jump on and cover those questions. But it actually gives us a chat log so that when we answer the questions, we'll also be able to add that to the materials that you'll receive. As I said, for FASEA in CPD, there's 4 hours. I think it's 1 technical hour, 2 client care, and 1 professionalism and ethics. So again, I think just from July this year, we have done over 35 CPE and also CPD hours. So certainly we're at that one-stop shop for all your materials. For the planners out there doing the investment side, obviously we're not really in there for you, but you know it's a really important one. So when we have a look at the for tax practitioner boards, we've got 4 CPE hours as it relates to structuring and tax work as well. So let's get right down to it. I mean, the succession asset protection estate planning space covers a wide range of structures and strategies, all with a goal of providing protection, essentially, if you like, and putting a moat around a client's affairs. So if you have a look at it, and this is the best I can put, is that, look, make no mistake, there is a multitude of lawyers seeking to Robin Hood your clients to distribute their wealth amongst a list of aggrieved parties. Now, of course, at the end of the day, everyone is going to miss out, because the more the fight, the greater the fight, the less there is in the estate for the aggrieved parties to feast on, because what happens is the lawyers have actually done it in the first case. So we've got an interesting scenario there, from our perspective, is that with the legal profession, and you've probably seen me, you can see over there, down on the right-hand side, we've got, Justice Jeremy Courtois from the WA Supreme Court, who was in absolute shock and disgust that a $600,000 estate effectively was eaten up by more than $500,000 in legal fees by the time it got to him, and it took 5 years of litigation. So that irrespective of the fact that he awarded quite a reasonable or fair and balanced amount to Angela Miller, who was the de facto for Andre Taylor for 14 years. At the end of the day, the award he made was all irrelevant, because the lawyers, the no-win, no-fee lawyers, virtually ate it up. Now, as I said before, if we have a look at $3 trillion to pass hands over the next 15 years, you can imagine how much litigation is happening. And you can even see there was a couple of cases down in Victoria where there was SMSF litigation. So, with the COVID, just expect over the next 15 to 20 years litigation to go through the roof. Now, the difference about this is that the no-win, no-fee lawyers, if you go and have a look at those, and I could pull up, hundreds if you wanted at the moment, but essentially there's no such thing as a no-fee. They don't take on the case unless they've got, a really good chance of success, which is why we do what we do. I mean, do we care that clients' estates are ravaged, that there is no control, there's no succession? For me, absolutely. So, if we build the moat right around them, and it can be something simple as a protector, as we'll see later on in one of the case studies, if we can build it, then when these lawyers come a knocking, they're going to have to get across the moat. And I can tell you, in my moat, there's mines, skanky water, crocodiles, and piranhas. And that's where we want to go. We want to make sure that we're there to protect our clients' wealth, which again goes back to the fact that it's absolutely imperative that you do one for yourself and understand where you're going. Particularly for all of you, look, I think it's crazy, but you'll see if you're just even on PAYG for us, for $198, you can jump on the site and do spousal wills and EPOAs. So that's 4 very big documents for $198. And you can't get that anywhere else in Australia. Now, our documents aren't, our documents are the best by far. And we use a process of Kaizen, and I'd encourage all of you that when you go through it from yourself or your clients, if an issue pops up, essentially what we want to do there is be in a position that you might come and say to us, Grant, or like your docs team, we'd like to add this, or we want to take this, or this doesn't make sense, or the client wants this. And if we don't have it, then we actually go through and build it in there. So Kaizen is a concept that the Japanese have adopted from Deming, or John Deming from US engineer, of continuous improvement. And I think that's really important. We're not like the other, like for example, our old now Infinity, which is now gone, it's now Class Docs. Effectively, we're not like them that it's just locked and loaded and you can't make changes. We want to encourage you to say, look, we find this better. And I know George Stubbs down in Tassie, you're doing a wonderful job helping us down in Tasmania pirate or plot through the navigation of EPOAs in Tasmania. And it's great to have you guys on board to do these sort of things. So Rodney, are there strategy and documents 100% guaranteed to keep out litigants? Look, nothing is guaranteed. So, but we'll go through each one separately, and we'll talk about how things can happen. It's very, very difficult in terms of obviously bankruptcy, but then there's other solutions, and Michael Jeffries will be coming in a little later on to talk about some solutions in terms of insolvency and bankruptcy for clients. I mean, if we try to obviously set a whole lot of stuff up, then we'll be going through. Phil, I'll have a look at that question of financial planning or accountant. Most of this advice, in fact, I would say 90% of the stuff that we're doing, we might talk to Tim a little bit later on, effectively sits on the accounting side, setting up a leading member trust. Wills and EPOAs will talk through with Tony on that one. Just as an aside there, I'll just put a little bit of stop press there. We have had a few accountants and also planners to a certain level. And in fact, we just had a chat with a couple of dealer groups recently whereby they've all slowed down on self-managed super funds, which I think in this current state of play around obviously the market, that there'll be more and more people, particularly Gen X and Gen Y, moving into SMSFs. They've slowed it down because of licensing or having to do an SOA. I'm not sure if you saw a service, we'll do a session on it certainly in the next 3 or 4 weeks with Tony. We've got Estate Planning 101, a 3-hour workshop, which will be coming up in November. So make sure you can come along to that. But for the price of $550, Abbott Morley will set up a self-managed super fund for your client, take them through all the potential questions that the tax office will ask, set up all the documentation, then allowing you to effectively carry on with your SMSF, so you don't have to worry about the SOAs, etc. So again, that's where Abbott Morley is there. We're there as the lawyer to the accountants and financial planning community. Okay, so this is what it's all about. If you have a look, we've got all our little turrets there. We've got over on the right-hand side there, you've got your leading member, SMSF. Then, right in the middle is our main wealth, which might be in our family protection trust. You've got, the protector and all the gifts. And outside, you can see we've got our houses and our cars, which are all registered, mortgages to the protector, and they're all tied in. But then we've got this great big moat around it. And look, the question that was raised, which is really important when we have a look at it, I mean, it's fantastic, Rodney, is that if we don't do anything, that we've got no choice about it. But if we do something, and there is enough litigation around to show what works and what does not work, that we should be pretty comfortable. And I'll go through that on the way. So thank you for giving me that heads up, Rodney. So when it comes down to building a successful and remember, when we're doing it all, a moat, when we're building a succession, asset protection, and also estate planning. And I have got some news. Tim talked a little bit later on. We are setting up a working group for the Succession, Asset Protection, Estate Planning Advisors Association. I'll roll that out a little bit later on. I'll talk about that. So I'd love you guys to get involved if possible. So we can do everything online. And I want to make this association unlike any other association. So we've all been members of the FPA or the Institute or the CPAs or IPA or SMSF Association, and we know what they're doing wrong, and we want to make sure we're doing the right thing and setting it up so it's nimble, fast, and really looks after the interests of our members. So I'll be talking about that a little bit later on. But the key points for us is, really to determine what's important to a person about looking after their family and loved ones. And here's the thing. This is not about just estate planning. I'm going to show you something a little bit later on. When I do estate planning, quite often I'll hardly ever use a testamentary trust. I'll end up using the protector to make sure that the estate has no assets on death. And the thing about that is that then protects me for family provisions claims. But that means I'm setting something up during life. So we need to protect a client during life and also when they die, and not only just one generation, multi-generations. One of the most important things, in fact, it was raised yesterday, is that when you get involved in this, you're getting involved with the family. You're getting to find out that succession plan. So, if mum or dad are not alive and it goes down to the next person, the next leading member, who's that going to be? And then the one after that. So it's important. It's crazy if you don't look at it, that next generation, which you're bringing in as a succession plan to control the family's wealth ad infinitum, you need to make sure you're doing wills and enduring powers of attorney with those people as well. It's absolutely crucial. So if you have a look at that, it's absolutely crucial that we go through that process. Unfortunately, I haven't put the PowerPoint slides up yet, but you will get access to all of these slides. They've got all the solutions at the end as well. They'll be available later on today. So once you've set it up, you've done your pricing, you create a blueprint, to deliver the desired life, asset protection, estate planning goals, using the right combination of vehicles that we'll show. And another one for the planners out there is life insurance. It's one of the things that's sort of dropped off the radar, but it's absolutely crucial when we're looking at that next generation, which I'm going to cover a little bit later on. So everything today we're going to look at in terms of case studies. The plan has to be simple, certain and easy for all parties to understand. And certainly the ones that we've done and we've had a look at and explained to clients through Abbott Morley. We do work with a couple of accounting firms where we deal directly with the clients on behalf of the accountant. Then essentially when we do that, we find the parties understand. In fact, they make quite a few changes to some of the wills and testamentary trusts, which is great. So if it's a fundamental structural change, we then put that into obviously the Lightyear Doc system. Ensure the person is left in charge of implementing the plan. So that might be the attorney, the successor director I'm going to talk about a little bit later on. If you become incapacitated or die, the last thing you want is your company to go down the tubes because it doesn't have an appropriate directorship. And executors and attorneys will have a look at that, and obviously ongoing trustees. Obviously, it's got to be super tax effective, and we'll look at that. Again, one of the best in town, obviously, is the self-managed superannuation fund. But really, these days, I'm seeing so many SMSFs that have got, obviously, their pensions in place, which is fantastic. But with the T-bar, effectively, they're locked out. So if you've got a sizable SMSF these days, which is going to be very hard for the next generation because of the general sort of the general account balance. You can't contribute non-concessional if you have more than 1.6 million inside the fund. So we need to spread the love anyway inside our SMSFs. But I do find, and here's a little strategy for you. In fact, we just got involved a little way. So Mr. Limmy, SAPEP is Succession, Asset Protection and Estate Planning. Succession, Asset Protection, Estate Planning. That's what we had as an older client who had quite a sizable sum sitting in their accumulation account inside their self-managed superannuation fund. Now, the issue about that, there was quite a sizable, I love that word, sizable, a taxable component, so that on their death, if it was paid down to their adult children, then obviously there's a 17% tax liability. Plus, obviously, if it's on the accumulation side, which we tend to miss out on, is that if there's sizable again, capital gains in the accumulation side, when those assets are either liquidated or paid out in specie, and again, you can't pay out in specie for death benefits. You have to do promissory note and a purchase back, but that's for another part of the course. What we want to do there is it might be easier to simply withdraw the money and settle it into a family protection trust, which I'll show you a little bit later on, a family protection trust. So again, that's tax effective, and then we can get all the children and grandchildren. So that's what we call an inter vivos trust, or a living trust. So we're effectively, it's like doing a will or distribution of assets prior to death. We've got to make sure it complies with the laws and minimise the legal disputation, which is pretty important. I'm going to put this up front. I didn't know where to actually put this slide, but for me, it's probably the really key fundamental. So again, going back to SAPEP, the first one, which is why I put it there, is succession. It doesn't make sense. I see so many of your clients' family trusts, and I have a look at them, and they might be from 1980, 1990. I did one from 1978 just recently. They need to be updated. And the benefit there is, particularly the accountant's going to say, what about resettlement and stuff like that? The commissioner has got a ruling, TD, so that's tax determination 2012/21. And I'll send you some links to these resources today. So this is, you're going to see this once, but you're going to need to see it a few times. So with that specific determination, the commissioner comes out and says, look, you can change vesting. Obviously, you're subject to the vesting laws. You can change jurisdiction of the trust. For example, a little heads up is when you set up a trust, set them up in South Australia, where as soon as you put in the jurisdiction for that trust, that's where effectively that jurisdiction applies. In South Australia, there's no rule against perpetuity, so it carries on ad infinitum. Same with testamentary trusts. They must be set up in South Australia. In fact, I'm doing one a little bit later on today. So what we want to do there is we want to have a look at, with that, for example, a family protection trust, which is the same as our leading member trust. We need to put in a line of succession. And when I explain it to the client, and I'll get Tim and I'll ask Tim a little bit later on this, is that effectively, do you want to ensure that your wealth is not only protected, but goes only to bloodline? So as soon as they say that, then you start to upgrade and move to more of a premium, although there's no difference in pricing on our site. It's more a thematic from your perspective, is you start to move down this succession planning. So if you have a think about it, the best one I always use the royal family to show clients what it's like, is that, once you set up one of these trusts, and if we set it up in South Australia, it goes for hundreds of years. The same with a self-managed super fund. Once a self-managed super fund is set up, it never, ever dies unless it is wound up. So unless the commissioner or the individuals wind it up, it never, ever dies. So what we need to do is show this succession control. And from that perspective, with the succession control, what we've done there is we need to have a look at effectively the royal family. And in terms of the royal family, so George Elias, can we set up a trust in South Australia where no one actually resides there? Absolutely. So you can do that. So when we have a look down the track, what we've got there is we've got obviously the Queen, it then goes to Prince Charles, then goes to William, and then goes to George. So none of the sidelings, I would put, have any opportunity to make to effectively litigate and say, look, you can't, well, not Prince Andrew, but Prince Edward can't say, look, I don't really want Charles in there because he's loopy. I think I should be in there. Effectively, it doesn't work there. Even if Charles abdicated, there's no way Prince Edward gets in. Effectively, what happens there, it ends up going passed down to William. And the same way is, if you go down Prince Harry, there's no way in the world he'll ever get to the throne because we've got Georgia, unless that whole line goes in some nefarious plot, who knows there. So when we have a look at that, when we have a look at those particular issues, and I'll come back to that South Australian one a little bit later on. So there's a couple of questions. So keep on firing questions, and thank you, Foxy, for your illustrative comments as well. So I'll raise those in a sec. So when we have a look at this idea of setting up a trust or setting up an SMSF, effectively, what we can do is we can go through, and as I said, you can replace an existing discretionary trust deed with a leading member family trust or leading member discretionary trust, which is exactly the same as a family protection trust. Is all I've done is I've just changed the names, and instead of leading member appointor, we call it a family protection appointor. So all of those, the commissioners basically said that effectively that is not a resettlement, and there's no capital gains tax issues in terms of that. So what it transpires from that one is that we need, for our own circumstances, to think in terms of our family trust. If we do go down that leading member, who's the first leading member? if something happens, and this is the process that happens, is in the event that you can see there the third bullet point, that if there's death, dementia, retirement, bankruptcy, divorce, or litigation, effectively what happens is that leading member retires. So if it's a leading member appointor, they simply retire or move out of the system, and likewise they move out as trustee as well. So then the next leading member appointor comes in to play. Now, part of that, it's what you've done there is effectively you've got rid of one line and then you've dropped down to the next line, and that gives us a certain amount of protection. Is it guaranteed in all circumstances? Well, from family law, you can't guarantee it, but certainly in terms of controlling that trust, absolutely. In terms of family provisions, claims, absolutely. So we've got a really good idea of succession. Now, when it comes into succession, and I'll look at it a little bit later on, but that if we set one up, and let's say it's from my perspective. So what we've got there is you've got me as a leading member appointor. Then the next person coming in may be, for example, my daughter as a leading member appointor, and also my wife. So they're joint leading member appointors. As soon as we get that joint, it starts to lose a little bit of control. So we really want to have someone who's strong and fierce and really is going to do the best interests of the family. Now, that person, that next person in, should also be the executor, should also be your power of attorney, and should also be the next leading member of the self-managed super fund. And then the one after that should also follow through there. So they should be the successor executor, successor appointor, the next leading member appointor and the trustee, the next leading member in the SMSF, so on and so forth. So if you can get this right, and think about it yourself, if you can get this right and it goes down the track, it really does make a huge difference there for us. So I've got a few questions here on South Australia. So what I'm going to do is probably, I don't want to dwell too much on this. What I'm going to do is, thank you very much for this. Let me do some research, and next week, next Thursday, I'll come out and do a session on how to establish a trust in South Australia with jurisdiction, how to change a trust jurisdiction by doing a variation, and also more importantly, what the requirements are. And then I'll go through the law there, obviously with Tony, and have a look at some of those issues. So thank you very much. It's great to have some of these questions coming through. So let me have a look from there. I've got a really good question again from Julie. Can de factos be classified as linear? It depends. The trustee can bring someone in, but you are going to see a de facto is obviously not bloodline. Even a spouse is not bloodline. You need to make a choice. When you build the fund, you'll see that you'll have the leading member appointor, and I'll go through this a little bit later on, but we have to decide whether the spouse or the de facto is included. And if they're excluded, then they're outside of the equation there. So you can, in fact, you can bring the spouse in and then cover the bloodline children from a previous marriage. But remember, the spouse, if it's brought in, if you want to protect their interest once the original leading member goes out, that spouse or the de facto, if you want them to have control, effectively they will be brought in as the next leading member, if that makes sense, Julie. So it might be John Smith as the first leading member, his second wife, Sally Smith, then comes in as the next leading member appointor for the SMSF and that. Now that in and of itself, you've got to be careful, Julie, because you have to tell John that issue will effectively drop out the bloodline children from a previous marriage. But if you had, for example, Max Smith, who was a bloodline child from the first marriage, and he was the next appointor, and we didn't put Sally there as the next leading member appointor, then effectively she drops out, or she's a beneficiary. So I'll go through this a little bit later on. I'll show you how I structure it and what to look for. So does the successor in Kush have to be a resident of Australia? No, not at all. So in fact, you'll see when we go into our system, with foreign persons, you can actually have a position there whereby we put in their overseas addresses as well. Generally there's no foreign issue if we've got a overseas a person who's the trustee. There is for self-managed super funds, obviously, there's a whole range of issues there. You've just got to be careful though, if it's a beneficiary, then obviously they're going to be taxed at the flat rate. I think it's 29%. So they don't get the tax-free threshold judo. So just be careful about that. But we're starting to see here that we can do these multi-country, this succession, and we'll go down the asset protection and the estate planning a little bit later on. But honestly, the succession is where to go. Think of it from your own perspective. I mean, if, for example, myself and my eldest daughter wasn't around, who's going to be the next one in there? What I would do there is, my youngest daughter's 18. There's no way in the world I'm going to give her any position. But what I'd do is I'd start to bring in my brothers, because they're still bloodline, they're DNA. So the difference between lineage is direct bloodline, whereas bloodline, I talk about it as being anyone who's got your DNA. So, for example, my cousin over in Adelaide has got my DNA. So what we're going to do is get this succession right. Plan it out, and you'll see when we do our data captures. And I'm starting to, okay, so Michael Fox, USA. Okay, so you've got to be very careful about that one. In fact, what I'll do, Michael, I might even get you in and maybe for next Thursday session, you can get in and give you a tuppence worth from all your experience if you're amenable to that. Otherwise, I will take a lot of that information. Again, the good thing about our group, our network here, is sharing is caring. We're setting up this SEPEPA association, and there's only a few of us. So we want to work in cohesion, cooperatively, there to really cut a big swathe through the Australian advising community in this very exciting area. So again, sharing's caring. So thank you very much, Michael. Hopefully we'll see you next week, which would be great. Okay, so that's a good point, Dave and Ruthenberg. I'll have a look at that one when we get to the data capture. Actually include the common parties, that's a great idea. So again, I think I've made 3 changes to the data capture, but I'll show you the one we've done very shortly. So get your succession right. And as David just said, when we come down and start building these wills and EPOAs, we want to put down all the parties that are involved in this whole plan. So it's going to be, for example, mum and dad, all their kids and potentially their grandkids, maybe even the brothers and sisters who are going to fall in line, who may end up being an appointor. They might be the 4th in line appointor, because if in case everyone's dead. But again, it's just these issues that really give us control. If you've got weakness, you think about it from your own perspective. Look at it if you've got a client or yourself, so you've got a family trust, and in that family trust, you're the appointor. You've then got a corporate trustee, so you've done the right thing. And then effectively, that corporate trustee, you're the shareholder, and also the director of the corporate trustee. You pass away or get dementia. What happens to that family trust? What happens if there's no EPOA? On death, what happens? Well, if you're dead, obviously there's not going to be an issue there. So you're not going to have that sort of position. But importantly, from that perspective is, we've got a scenario that if you pass away, the shares of the corporate trustee end up in the estate. And if that estate is challenged, it can take 2 or 3 years for it to guess exactly where we're going in relation to that. So discretionary trusts, SMSF legal estate, as I said, ideally your EPOA equals your executor equals your successor leading appointor and successor leading member in SMSF. So if you can get that one right, get that into our noggins, that's the thing. So that we've then got super amount of control as to exactly what we want to do. And that's going to be important when we have, for example, the protector, which is a loan of money from the family protection trust or the leading member trust. down to the individual who's done that gift over, which I'll show you a little bit later on. But importantly, from that perspective, is that on death, the executor will pay out that loan, which is absolutely crucial. Okay, so this is the old structure that we tend to use. You've got your bucket company, your discretionary trusts, you've got your SMSF and wills, you cross that line. So quite often we'd have our lawyers that, and you see it quite a lot. Okay, yeah, I saw that one. So thank you very much, whoever turned up around your SMSF and green card or USA citizens. So they're, in fact, Dixon is in huge trouble at the moment. So make sure you have a look at that. I might raise that at an issue about foreign superannuation funds at a little bit later on, particularly when it comes around to SMSFs and what we've got to do. But enduring power of attorney is in fact perfect when it comes down to controlling SMSFs in Australia. In fact, we had a issue from one of the dealer group's compliance managers was saying, how is it possible, for example, to have one member of the fund, have one trustee of the fund or one director of a corporate trustee and have multi-members? And it's quite interesting from that perspective is that as long as they've got the enduring power of attorney, they can cede or give up their trusteeship to the person who's got their power of attorney. So you can have, for example, if we go down to the 6-member rule, which I'm expecting to come in around about February or March next year, probably March next year, when government comes back to sitting, that in that perspective is that we could have a 6-member fund with one trustee only. And it was funny because the compliance manager said, surely that's not in the spirit. And then we had a look at the commissioner's ruling on enduring powers of attorney. And the first example that he gives is that a couple of clients are overseas. So to protect the central management control, which is to ensure that stays Australian super fund, they provide their EPOA to their accountant, and their accountant now becomes the trustee of the fund. And while those EPOA is in force, it still remains an Australian resident super fund. So this issue of one member, one fund really is a bit of a furphy if you've got some issues stuff there. Michael's going to be coming on a little bit later on, talking about our upgrade to our system. So like your Docs 2, which is to be launched, we expect in April. So he's had a lot of work on that one, bit beyond me. I just do it, but I just tell them exactly this is what I want. So this is our moat structure. Essentially what we're looking at doing is getting our leading member discretionary trust. So this is our business vehicle here. Family Protection Trust essentially has got only assets in there that really are not going to be subject to litigation or there's going to be issues with them. So that's our Family Protection Trust. Our leading member discretionary trust is obviously going to be the trust that will run our business. You've got our bucket company down there. We need to make sure we also put a succession plan around that. And that's the successor directors is absolutely crucial. Also take the equity out of that, which we'll see later, and put that into the Family Protection Trust. A leading member SMSF, a leading member SMSF trustee company, wills and testamentary trusts, and you've got the executor. But remember, the executor is also the power of attorney, is the next leading member here, is the next leading member there, and is also the next family protection appointor in that instance. So that's essentially where we are in terms of the moat structures. Now, because this is a pretty new area of expertise, I shouldn't say it in terms of the legal profession, because certainly the lawyers provide estate planning out there. They generally don't do much succession. They tend not to do a huge amount of asset protection. But in terms of the estate planning side, what we have is from an estate planning side. Sorry, that's my dog who's just decided to come in and have a bit of a hurly-burly in my office. From an estate planning side, they'll do that. But I want to go through the 5 reasons why accountants and financial planners are best at this SAPEPA stuff, or this SAPEP stuff, succession, asset protection and estate planning. Now, where we are, we're down at that enthusiast. So we're all busy innovating, building data captures. Tim's doing it, I'm doing it. We're all throwing around our ideas So we're actually building a brand new profession, which really, look, I'm there at the front, as is Tim, as many of you, is I've made a huge switch. And for those of you who know me, I've come from that SMSF space. So I've moved from there into this PEP space. Now, SMSFs are a small part of it. In fact, only $300 billion is going to switch hands in self-managed super funds over the next 15 years compared to 3.2 trillion elsewhere. So this is where I want to go. So we're down here, and then at some stage, the momentum will come, and then we'll get the early adopters. A little bit later on, whether it ever happens, we're going to find we might find more and more people taking on this profession. And just to give you an idea of how it works is that I set up the SMSF Professionals Association with 20 people in a working group, foundation members. We work through that SMSF Professionals Association, corporatised it, got a director, set it up for the prime reason of being able to be in a position. If you go back to 1999, 2000, no one would call themselves a specialist SMSF advisor. Now people will, because there's an association that gives out accreditation being a specialist SMSF advisor, which is where we're going with this down the track. And the key people will be the accountants and also the financial planners. So from my perspective, there's 5 reasons why you are really the best when it comes around to succession, asset protection, and all estate planning. If you have a look at it, a lot of your clients that you're dealing with have sizable assets inside discretionary trusts and SMSFs. So they've already been put in there for asset protection purposes, but they haven't got that succession in there. They haven't got that durability, that control in there. So they work well until someone dies or you've got dementia, and then there's problems with that one. So important, those assets don't form part of the estate. Potentially in SMSFs, the notional estate concept under family provisions claims in New South Wales, potentially they do, and that was in Kirby's case. But for the rest of Australia, basically okay. So the reason one, accountants, you've got a good idea of the client structures. So you know bucket companies, you know companies really well. You know what a discretionary trust is, what a unit trust is. You're not sure necessarily about the estate planning, the wills. You know what a binding death benefit nomination is, but really it's, not really au fait with how deep you can go into it. And so what we can do there is you've got a really good understanding there. Now, for the planners out there, you're not dealing with trusts on a day-to-day basis. So the main thing there is do what you feel comfortable with. So if it's the estate planning and also it's the estate planning side and the enduring powers of attorney, advanced healthcare directives, which we're getting up, enduring guardianships, then put that as your quiver of arrows and just stick to that. But for those who really want the full-fledged experience, the SAPEP experience, then you need to get over that top there. So Phil has got, if a family protection trust is set up before death, do child beneficiaries enjoy the same tax thresholds as adults? No, unfortunately. So if we do it before death, we don't have that. That's a really good question. We don't have that. You'll see, I will talk later on around SMSF Death Benefits Trust. I won't have time to go into the legislation, but Section 102 AG2, the tax rules that provide just what Philip said is that minors are treated as adults. So one of those ones is for a testamentary trust that is created out of a will. So if a trust is created out of a will, we call it a testamentary trust, but there's no such name typically. It just talks, testamentary obviously mean it's created on the death of the testator or the deceased. So from that perspective, what we have there is a scenario whereby if we have a look at 102 AG4, there's an ability to create a trust that has the same children to be taxed as adults, but it's created by the trustee of the SMSF. So let me just explain that a little bit later again. So if we leave our assets, so if we leave our assets in our estate and we put a testamentary trust around it, then children under the age of 18 are taxed at adult marginal tax rates. Now, they've actually put in a couple of new rules around that, which I'm going to have to do a session on a little bit later on. But notwithstanding that, there's another section in the Act which is hardly ever used, mainly because lawyers don't necessarily deal with superannuation. They don't understand it. So what they'll do is they'll pass it over to the estate. The problem about passing it over to the estate is a family provisions claim comes into play. The alternative is, and let me go through this again, on death, if your SMSF will, because obviously BDBN is not going to cover it, if your SMSF will says or gives the option for the trustee of the fund at the request of the beneficiary, or if there's just children, can do it automatically, can set up a family protection trust or a leading member trust. We call that an SMSF death benefits trust, and that children or minors are taxed at adult tax rates. So it bypasses the estate and is paid out directly from the super fund. The payout, for example, might go to an adult child, which is then settled into that family protection trust, the SMSF death benefits trust, and then children get to enjoy the adult tax rates. So I think that is absolutely crucial, and good question again there, Phil. So when I talk about an SMSF death benefits trust, it doesn't ever come out of the estate, ever. You might have heard of super proceeds trust. That comes out of the estate. It's a testamentary trust. But again, that's subject to a family provisions claim. SMSF death benefits trusts aren't. There's only one possible exception, that's in New South Wales. I've got another question. If you have an old structure to convert to the new LY structure with a family protection, is there stamp duty? Generally, there's to upgrade the deed, there's generally no stamp duty consequences. So when we do that, again, there's no resettlement. What I'll do is I will send the Commissioner's guideline and ruling on that. He's gone through huge amounts of cases saying there's no change, it's not a new trust. So obviously there's no stamp duty as well. We've got a good question there. For children under 18, if they take a lump sum, it would come out tax-free anyway, which is absolutely the case. It's better. So that's a really good question. We've got children under 18. They would get the superannuation tax-free. Now we've got an issue there is, does it get passed into the estate, or does it get passed into a family protection trust? Because there's 4 ways in a self-managed super fund for a child, and this is important, to receive monies. The first one is to receive a pension from the fund. So if they receive an account-based pension of the fund, it can only go up to age 25, which you're probably well aware of. The taxable component, that portion of the pension which is paid out, effectively is assessable, less, but it has a 15% tax offset. The alternative is we can pay out a lump sum to the child who's under 18 tax-free, but good luck for that one. No one's going to want to do that one. The third option, which I talked about, is you can then use that money to settle it into a leading member trust on behalf of the child and put terms and conditions on it, which we'll look at a little bit later on. That again, that settlement sum will be tax-free. So it's a capital amount that when it's paid back to the child, so let's say we've got a condition on paying back of capital till age 25, when that comes out, that will be tax-free. Or alternatively, we can pay it over into the estate, and that will then form part of the estate as a so thank you for putting business restructure stamp duty free. Thank you. So when we put it into the estate, again, we put it into a super proceeds trust for the child, into a testamentary trust. Again, that capital will be tax-free. So it's the same as the SMSF death benefits trust, except as soon as I put over to the estate, obviously it's going to be in a position of being subject to a family provisions claim, for example, if it's a second spouse or whatever, which we'll get into. So again, my preference is always to pay directly out of the SMSF, don't go in. So you can start to see this is where this protection comes in, going back to the original, remember the original question that Rodney asked is, you know, can we ensure that it's going to be a great, you know, it's going to give us protection? Yes, if we do it in a certain way, that will make a big difference. And again, commercial real estate stamp duty issue as well there. So why the SMSF Death Benefits Trust didn't follow the logic, since you said the advantage was for minors. So the logic there is, in fact, that's a really good question. So the logic is, when the money comes out, if I've got, for example, a child who's age 16, if I take, let's say there's a $100,000 payout from the SMSF, it comes out, obviously it's tax-free, would go into the child's name. The child then invests that money, and when they receive income from that money, obviously it's going to be taxed in fact, unless you can fit it under 102AG, it'll be taxed at marginal rates. Whereas if we put it in the SMSF Death Benefits Trust, there's that capital amount, which is tax-free, which is exactly the same position, but any income on that that's distributed to the child while they're under 18 is also tax-free, because it is a testamentary, it's not a testamentary trust, it fits under 102AG4, if that makes sense. So the logic there is not on the capital, effectively the logic is on the income, or the fruit of the tree, the income that flows from that capital. So reason one, you can start to see we're starting to go through a lot of these structures and issues. And again, this is where these questions are great, and look, feel free to jump on support or ask us at any point in time, or if you want a session with Tony and I, there's no cost on those ones. Secondly, lawyers lack tax knowledge of discretionary trust and SMSFs. And I think that's, there's a few lawyers around that are, really good at the trust side, for example, DBA and all that. But around the whole thing, there's a very limited amount. You can't just go down to your local solicitor and say, okay, well, I want an estate plan, I want to do this, because it's just not going to work. You're not going to get that succession in. This is my important one, reason 3. Accountants and planners have long-term relationships with clients. Generally, when you go into lawyers, it's a once-off relationship. And I know from my own issue with my father recently, who passed away, and when he passed away, we had to dig around everywhere for the will. And half the wills were signed, half weren't, and they were all sitting in the lawyer's office. So look, my preference is to make sure that you guys do it in-house. We'll talk to Tony very, very shortly around about the process and system of what you can and can't do, and more importantly, how you can avail yourself of Abbott Morley in that regard. The fourth one is the trusted advisor. I won't bring up the Princeton study, but effectively in terms of trust, lawyers rank alongside prostitutes, which I thought was quite funny. So no slur there, Tony. I'm sure you're not that case. But essentially there, it was in terms of warmth. The lawyers are very good at what they do. I'm assuming their prostitutes probably are as well, so I shouldn't talk about that one. But they're very good at what they do, but they're not warm, and it's an in and out relationship. So you send it to the lawyer, they do their stuff, and effectively there's no upside there for you. So there's no fee in it for you. Really, if it's a bad experience, it reflects poorly on you. If it's a good experience, it's great, but that takes a long time. You're going to see when we get to the moat, it can take weeks or months to complete the moat, in something you can do virtually within inside an hour once you experience. Reason 5 is the whole family. So as I said, you're looking at the family unit. You need to be doing an offering to the client when they come round to doing an offer, to make sure that you are not only doing it for that client, but you're doing it for the spouses, you're doing it for their children as well, and that's EPOAs. It's also wills, and if they're all embedded in the SMSF, it's SMSF wills as well. It's life insurance. It just keeps on going down. One family unit can turn into a sensational client there for you. Okay, so let's go through the legal side of advising, and I'll get Tony coming in. So you there, Tony?
Yep.
Okay, so I'll just go through this first slide, and then we'll punch in with you and have a look at how everything fits in, because it's just one of those things that always gets up. I don't want to cross that line of providing legal advice, and certainly we don't want you either. Now, if you know our system is based on an interview style, so it's very, very sophisticated. And when we come down to it, we just got to be really careful about understanding where the line is drawn. At any point in time, again, you can contact Tony. He'll go through and tell you, but we've got a letter of advice from Tony around this. But importantly, at this stage, if you're a lawyer, you can't call yourself a lawyer. I can't call myself a lawyer because I haven't gone through. I'm not a practicing solicitor, whereas Tony is. He can call himself a lawyer. But the same thing, he can't call himself a financial planner or an accountant unless he's obviously able to do that, or a real estate agent. In fact, there was a case going back in 2012 where a lawyer was pulled up in front of the real estate board down in Melbourne for impinging on work that a real estate agent would ordinarily do, and they hadn't in fact gone through the relevant courses to do that. So they ended up getting fined as a consequence of that. It's quite interesting too, and I read a paper going back in, I think, the mid 2014 or 13, where a solicitor, and you see this all the time, saying that effectively accountants and tax agents aren't allowed to give tax advice because it's legal advice, notwithstanding the fact that there's Commonwealth statutes enabling you to give tax advice. And the same with planners. When you have a look at it, for most part, your SOA is really a legal letter of advice, and it's underwritten by the Corporations Act. So we've got all these we've got all these different blurred lines, and all of you have set up online, whether it was through my old firm now, Infinity, whether it's through Lightyear Docs, whether it's through Clear Docs, Top Docs, etc. We've all set up pensions. A pension is a contract between a pension beneficiary and the trustee of the fund to pay an income stream according with some rules. We've all set up SMSFs, trusts, unit trust companies. We all set up those loan agreements, Div 7A loan agreements, B2B ends, all of that sort of stuff are effectively agreements that prima facie are legal agreements. Now, there has been one case, and this is in Western Australia, whereby an individual who was selling franchises of creating wills, and he was not a lawyer, was effectively pinged as providing legal advice. And the reason was that he was training people up not to do what we're doing, which is, this is the legal guts of it. All you can do is just fill in the relevant data capture. He was completing that and training people how to draft the wills from scratch. And of course, that was held to be providing legal advice because he was drafting legal document. So what I'll do is, Tony, do you want to jump in and talk about, I've got 2 slides here, actions that are legal services and providing legal advice. And if anyone's got any questions, put it on the Q&A and I'll ask Tony. And then we'll go to what is not, and then we'll talk about the sign off.
Yeah, that's fine. So as you can see on this slide here, basically there's a few points, for the provision of legal advice, drawing, drafting documents, giving legal advice, appearing in court, obviously, and using the name as a barrister and solicitor, which is not the case. Can you hear me now, Sally? Grant?
Yeah, I can hear you. So just speak up a bit closer. You're really good this morning. So
I know. Can you hear me now?
Yeah, definitely.
Everybody else can hear me? I hope so.
Oh, yeah. So that's Sally is much good. Yeah, Sally's got a hearing issue.
Let's continue. So that's for the provision of legal advice at the moment. So if we let's go on to the next slide and see what's not legal advice now.
Sorry, here we go.
Okay. So actions that are not considered to be legal advice is undertaking work in association with the law will not necessarily constitute engaging legal advice. And these examples are clerical, administrative tasks, such as inserting parties' names in a document, even selling legal documents, and or advising of incidental legal requirements by a person in pursuit of an occupation other than law. So tax agents obviously can advise on the requirements of tax legislation, but they can't go to the extent of drafting legal documents like a will, right? That's a lawyer's job at the end of the day, right? So essentially, what you're really doing from an estate planning process is you're collecting data from that interview sheet, and you're inserting that data into the system, which will then spit out the will, because the will's already been drafted. It's been checked, it's been drafted, it's been vetted. So you're not really providing any legal advice. That's our job. Okay, and we'll get to that point a little bit later.
That's a pretty good process, because you and I have been through it, and you've worked in legal firms, and I've seen the process. Generally, and this is why it's funny, because I think accountants and planners take up technology really quickly, but traditionally, and tell me if I'm wrong here, Tony, because you've obviously got a lot of experience.
Yep.
Traditionally, if someone comes in and says, okay, well, I want to use I want to do a unit trust, or I want to do this or whatever, and they've never done one before, the lawyer will jump on to LexisNexis or Leap, and then they'll download a Word precedent. Inside that Word precedent, there's a whole lot of usually instructions in there that says, okay, well, if you do this for this one, or do this for this, or check this. And so what they have to do is they then have to create it, ask all the questions, and then build it from the ground up. So that's drafting. Am I correct in that one?
Yeah, you're drafting. That's what you're doing.
Now, that's the thing, is once you're looking at that, that's the process. So you can imagine how long that takes, because they've got to go through the whole document, work out how it is, draft it specifically bespoke for the client, but they're not working in a system. They're actually working on a Word doc, which is why when you go and do wills or something where it's not just set down easily, that effectively can take weeks to come back, because they've got to spend the time drafting, etc. As opposed to, as Tony said, when we come round to using the system, which we've then got here, the Abbott Morley advice. Do you just want to go through that one?
Yeah, that's very important also, because what happens is, because the system is inbuilt and it's got legal protection and security measures around that, you can't go outside the scope of that. Basically, you can't go in and edit or convert the PDF document into a Word document and then start drafting as a result of that. Otherwise, you're in breach. You're out, so you fall outside that that provision, and you'll be considered, basically, it'll be construed that you're giving legal advice and drafting documents, which you can get into trouble for that. Basically, I've seen it done before.
You might just want to talk up a bit. A couple might go, and they're still having a bit of trouble, but yeah, just speak up a little bit. And Michael, I did get him a really good mic too, believe it or not.
Yeah, I know. I've got the mic here, so I can't understand why.
Okay, just keep on going. Sorry about that.
Yeah, can you hear me?
That's perfect. That's perfect now.
Oh, perfect. So, so you can't go outside the scope of that. Otherwise, you'll be in breach of the, under the Legal Profession Act. Basically, that's what'll happen.
Yeah. So from our perspective, we take and we're going to look at the data capture. So I'll do this case study. I'll show you the case study. Then we're going to have like a 5-minute toilet break and stuff like that. And then what we'll do is we'll come back and start to build through the data capture, etc. So we'll come back and we'll have a look a little bit later on, Tony, once we get through that case study. So what I want to do now is I'm going to leave this up on the screen, and then what I'm going to do is I just want you to sit down and we'll have a 5-minute break. we'll go for a toilet break, a cup of tea, cup of coffee. So we're first hour in, we've easily achieved it. So we've got a lot coming. But what I want to do is I'll come back and start building the documents from the data capture. And I'll show you exactly the process that needs to be done. But in the meantime, what I want you to think about what are, exactly what you would do in this instance. So this is what we call a very simple will, a very, very basic will. So we've got Max and Samantha Smith. They're 37 years old and have two daughters, Janine and Kathy, who are 4 and 2 years old. They've got their own family home, which they own jointly in Fairlight, New South Wales, which is currently valued at $1.6 million and has a $600,000 mortgage on it. Max is a director in a large construction firm on the northern beaches of Sydney and is paid $140,000 per annum. Samantha has an Amazon store, which she operates just as a sole trader, where she sells her small line of mum's clothing, so that's her brand, which is gaining steam and turns over $15,000 per month with a $5,000 profit. Sounds like you, Sal. Max and Sam are in Australian super, with Max having $160,000 and Sam $50,000 as well. Now, they want to get wills for each of them. Now, I would say there's probably not only need wills, but they also need enduring powers of attorney. So what I'll do is I'll just stop there and then effectively we'll come back in 5 minutes. So the time I've got, I'm up in Brisbane, so I'm an hour behind. It's 9:16, so 9:17. We'll start back at 25 past 10 your time, or 25 past 9 our time as well. So in the meantime, we'll see you back in a few minutes.